also for the filing of written submissions. That did not happen. And there were revised directions, later dates for doing the same thing that had been directed in December. That has still not happened to this day. What do you expect us to do today?
Yes. Thank you, Justice Madlanga. Justice Madlanga, can I say this as the first thing? I'm dreaming to appear before this court for a long time, and I wish I was meeting you today on a different circumstances, favorable ones. Just to get back to your question, Justice Madlanga, it is correct. We've seen in the correspondence that our house is not in order. My attorneys here, the difficulty has been to secure the record. You'll have seen that a record was filed, but it's incomplete. But the point is that a crucial part of that record that was filed is not part of the main record, Justice Madlanga. I've advised my attorneys to say we need to obtain a complete record. Of course, to approach this court to ask for an indulgence for us to do that. We have seen the letter that was written on the 22nd of February 2022, Justice Madlanga, where they document the difficulties that they are facing with securing the record, Justice Madlanga. And the reality, as I speak to you, that of course that has not been done. The difficulties still persist. I want to point out at this stage, Madam Mr. Madlanga, that the missing part is quite crucial for me as counsel to present a proper and full case for this court. And of course, by extension, to do justice to the client, Justice Madlanga. So under the circumstances, Justice Madlanga, and of course, I apologize profusely for this mess that will come before you after you've given us about 2 times the direction to get our house in order, and we failed, Justice. But what I'm asking today
is writing letters to the court after non-compliance with directions the proper thing to do?
Justice Madlanga, we could have done better. I think an application should have been brought before this. But Justice Madlanga, having said that, I take the point that it should have been more comprehensive and formal and brought a proper application. But my submission to you, to this court, rather, Justice Madlanga, is that yes, we did not do an application, but we did not sit back and do nothing. In fact, this letter of the 22nd.
We do not know. We do not know that you did not sit back and do nothing, because there's no substantive application before us explaining on affidavit what has been happening. So we do not know. You cannot even begin to say you've not been sitting and doing nothing. Not when there's a substantive application supported by affidavit telling us what's been happening. And what makes the situation worse is the fact that the second set of directions, in so many words, invited an explanation as to why the first set of directions was not complied with. Obviously, that required an affidavit to say, we did not comply with the directions of 20 December 2021 because ABCD. There's not even that affidavit explaining that. You know, the court specifically says, file an affidavit explaining why you did not comply. That means nothing to the applicant to this day. And then from the bar, you expect us to accept that you've not been sitting and doing nothing from the bar. In fact, for something like this, the court does not even have to invite an explanation. This is something that must happen automatically once you do not comply with the rules, once you do not comply with directions, a substantive application is brought to explain the non-compliance. That's the proper thing to do. That is what a court always expects. And that is what a litigant must do as a matter of course. Is that not so?
Is indeed correct, Justice Madlanga. Justice Madlanga, like I said,
back to my question, and please just give us a straight and direct response this time. What do you expect us to do today in one short sentence?
Madlanga, we asking of you. Of course, we humbly asking that at this stage, not proceed with the matter. You strike the matter off the roll to allow us an opportunity to get our ducks in the row. Like I've indicated, Justice Madlanga, that we need this information that is not in order for us to present the proper case before you, Justice Madlanga. And again, I cannot overemphasize the apology that I proffered before you for this mess, Justice Madlanga. That's what we're asking of in one or two sentences.
Thank you very much, Mr. Gama. Ms. Kaulas, is there anything further, Mr. Gama, or is that?
No, that is all for now.
Thank you very much. Ms. Kaulas, is there anything you wish to say?
Justice, I have nothing to say. I just feel that at this moment, the matter is not ripe for hearing. And in terms of the rules of the court, it should be removed from the roll. And when the matter is ripe for hearing and the record is in order, the applicant can then put the matter back onto the roll for hearing. Because obviously we cannot argue on an incomplete record, and that's what we're sitting with here at this stage. I cannot make meaningful submissions on an incomplete record. Thank
you, Ms. Kaulas. Colleagues, Mr. Gama has himself asked that the matter be struck from the roll, and I'm inclined to go by the route he is suggesting. Do all colleagues agree that we go that route?
Yes, agreed.
Thank you. Thank you. The application is struck from the roll. The court will adjourn.
Thank you, Justice.
Today's proceedings have concluded. The host will now terminate the meeting.